Hello everyone and welcome back. In this video I'm going to talk to you about the consequences or potential consequences of going to the courthouse and petitioning the court for an assessment order under the Baker Act. So I just had a call from my mum, just a really sweet lady. She's got an adult child who has she's early 30s, was diagnosed about 4 or 5 years ago with a mental health issue that required medication. About 3 months ago, she started to use very hard recreational street drugs. And the mother went to the courthouse and filed a petition for assessment under the Baker Act, which was granted. The court issued the order, authorized the police to go and get this young lady, and they took her to a facility. Now, the mother had said, no, I wanted to go here, and the court didn't send her there. Well, the statute says that law enforcement is supposed to take the person to the nearest receiving facility. And as I've mentioned in other videos, once somebody is Baker Acted, your rights as their parent, as their guardian, are terminated. And not only are your rights terminated, but their rights are terminated too. So your ability to decide where they go for treatment, what treatment they get, what treatment they don't get, is done. I mean, you don't get to make those decisions. And I said to the mom, why did you do that? She said, well, I was trying to get her help. And I said, I appreciate that, but the Baker Act is not designed to help anybody. It's a statute that allows the state of Florida to take custody of somebody when there's an emergency mental health situation. And obviously, my feelings are that, first of all, the Baker Act is not designed to treat anybody, but more importantly, if it's an emergency and you have time to run to the courthouse and fill out the documentation, get a court order, get it executed, then I have to say to myself, well, if you have time for that, then why don't we take the time to file the right kind of petition, i.e. a guardianship, i.e. a Marchman Act, so that the family, you, can retain control over the situation and make sure that your loved one gets the help that they need. Now, if there is a true mental health issue, and actually, ironically, this morning I got a text from another lawyer about a client who was somebody in their family was having an issue and said, oh, can I go to the courthouse? And I said, you don't need me to go to the courthouse. The Baker Act statute is designed so you can call 911. Have the police come down if it's that kind of crisis. If it's not that kind of crisis and the person needs help, then we have to talk about an alternative. Because once you Baker Act them, right, first of all, they become a temporary ward of the state. I just did a video about in loco parentes, right? The state becoming the new parents of this individual. And one or two things are going to happen. Either they're going to get detained for 72 hours and then let go. I don't think that solves the problem. Or they're going to get detained potentially up to 6 months and sent to a state hospital. And I don't think that's going to solve the problem either. So the Baker Act is just not your friend when you're trying to really help somebody. It's only for the type of situation where you would pick up the phone and call 911. That's what it's designed for. And when it's used correctly, it's a very powerful life-saving tool. But if you have a loved one who is in crisis because of mental illness, substance use, both, then don't Baker Act them. Not if you want to be able to help, really, really help them. So with that said, thanks for tuning in. Please give me the thumbs up and subscribe to the channel. Thank you. Bye-bye.